Mississippi. 1 year later, August of '97, John Wesley Don was found, and I quote, guilty of murder in the second degree, and that they do fix his punishment and confinement in the penitentiary of this state for a period of 20 years. Don's attorney entered the motion to set aside the verdict and grant him a new trial, but that was overruled, disallowed. Next day, Don was granted an appeal to the Tennessee State Supreme Court. Bond was set at $5,000. I don't know if he made bond, I seriously doubt it. He probably stayed in jail, and it might have been to his benefit to stay in jail if people wanted to lynch him. In September, the Supreme Court upheld the conviction of murder in the second degree and a sentence of 20 years. The court did concede that, and this is a quote. Don seems to have been an unwilling instrument, for he seems to have been fond of his aunt. He was, however, dominated by Gibbons, of whom he was afraid. It is probable that he did not intend the gun should fire that took the life of his aunt. November '97, at age 18, Don arrived at Brushy Mountain State Prison to begin his 20-year sentence. And through prison records, I found that he was only allowed to write one person, and that was his mother, Dorcas Baxley. All right, let's go back and see what happened to Gibbons. The court found the defendant guilty of murder in the first degree with mitigating circumstances. Gibbons' attorney moves the court to set aside the verdict, grant a new trial. Said motion was overruled, disallowed. Court being of opinion, there was no mitigating circumstances. Now listen carefully to what a part of what the judge said. Doeth order in the judge that the sheriff of Jefferson County take the body of the defendant into custody and him safely keep until Friday the 19th day of February, 1897, when within 2 miles of the courthouse of said jail of said county, between the hours of 10 a.m. and 4 p.m., within an enclosure as provided by law in such cases. Said sheriff will hang the defendant Charles H. Gibbons by the neck until he is dead, dead, dead. I don't know why they needed 3 deads, but that's a quote. Gibbons' attorney asked the verdict be set aside and the new trial granted. Court overruled the motion. Gibbons' attorney then asked for appeal to state Supreme Court. Appeal was granted. Now, evidently, the Supreme Court did not hear it because it's back in the circuit court, and he was once again found guilty of murder, and once again they said he was to hang by the neck until he was dead, dead, dead. His attorney then asked for appeal to the state Supreme Court again, and appeal was granted. Now, I have the brief from the Gibbons that went before the state Supreme Court, and it contained a lot of lawyerese about why certain testimony and evidence should not be allowed. But there was no date on the brief, and I don't know exactly when the case was heard. And I do not have a copy of the trial.